And my mind as a court, my understanding, my reading, is that in recent past, there have been numerous reports of senseless murders targeting persons of female gender. Let this not just be my words from where I sit. In an article dated the 26th January 2024, Amnesty International Kenya noted that a woman is killed in this country in every 2 days. And I will quote from the article so that I attribute it to where it belongs. Let me read the caption from that article. Amnesty International Kenya strongly condemns the profiling, torture, and killing of women and any other individual based on their identity. Over 10 cases of femicide have been reported across the country since 1st of January 2024. That is, every second day, a woman has been brutalized and killed because of her identity. According to statistics from Africa Data Hub, between 2016 and 2023, over 500 women have been killed. The majority of those murdered were below the age of 35 years and were killed by intimate partners or people known to them. According to the Africa Data Hub, a regional network of data organization that traces such killing based on newspaper reports, it states that about 500 women have been killed in Kenya from January 2016 to 2023. And let me draw ourselves back home. In an article published by the Daily Nation on 27th of January 2024, it indicates that 16 women have been killed since January 2024. The most disturbing was a case of Rita Mweni, a 20-year-old student at Jomo Kenyatta University of Agriculture and Technology, who was lured to a short accommodation apartment at Roysambu, common known as Airbnb. She was murdered, her body was dismembered, her head was dumped at a different location, and one can only but consider the words said by Dr. Jansen Odwal, the pathologist. And these were his words. He said, "This is the first time I've come across such an incident in my forensic life. I have never come across such an incident." And so when we are considering the public's denunciation of a crime, one cannot live outside the prevailing circumstance in the society. It is the understanding of this court that these reports speak to a situation whereby the social fabric of the society has been torn into two, right at the middle. And the court must then live to its role to protect the society. And so, having ruled out a non-custodial sentence, and may I just say this, the accused person is also not even asking for a non-custodial sentence. I read the submissions on mitigation, and in their own writing, they tell this court, Muratetu did not declare a death sentence to be mandatory, but then the court can give a custodial sentence. They say a custodial. There is nowhere in that report where this court is being invited to consider a non-custodial sentence. So we are at a stage of a custodial sentence. And I've already made reference to the sentences that this court can pronounce under Section 24. fast-track the judgment. The following factors have been considered by this court as I come to the tail end of the judgment. And there are only 3 sentences that are open to the court. A sentence for a term of years, life imprisonment, or death. The question that we all must ask is this: how many years, and what would be the basis for those years? Secondly, and for the lawyers before me, and today I am well populated, thank you for coming. We are all aware of the jurisprudence on life imprisonment, where one of the courts has said it is unconstitutional. The latest decision which I've quoted in this matter says that life imprisonment is 30 years. So the question that one would then ask is, if life imprisonment, and of course it's acceptable, it doesn't mean the life which that person will physically live or be alive. So if it's 30 years and with remission, then we'll be looking at where this court is sentencing the accused person to 30 years. With remission, he serves 20 years and his life moves on. These are issues the court had to think of. I have, of course, taken into account issues of human rights. I have taken into account Article 26, that says a person's life should not just be deprived without good reason. I have made reference, and maybe I should then let you know, to the international instruments that speak, and I need to do this because it's important, to the preservation and the right to enhance an individual's human rights. The International Convention on Civil and Political Rights, which has been ratified and which then of course becomes part of our law under Article 2, Sub-Article 5 and 6, says this, and it's important that I read it out because you need to know that. It starts by saying every human being has the right to life. And I stop there and I tell myself as a quote, every human being has a right to life. That every human being includes the victim and the offender. It then says this: this right shall be protected by law. No one shall be arbitrarily deprived of his life. Most of the time when we read these provisions, we speak to them as they relate to the offender. My understanding is they relate to both the offender and the victim. That convention states as follows: that in countries that have not abolished the death penalty, a sentence of death may be imposed only for the most serious crimes in accordance with the law in force at the time of the commission of the crime. So these international instruments that speak to human rights do recognize that there are exceptional circumstances when the death sentence may be inevitable. Let's look at Article 4 of the Africa Charter on Human Rights, on Human and People's Rights, ratified on 23rd of January 1992. It provides that human beings are inviolable. Every human being shall be entitled to respect for his life. His, in my considered opinion, includes her life. and the integrity of his or her person. Again, it reiterates, no one may be arbitrarily deprived of this right. Muratetu reflected again. The Supreme Court says that you can indeed impose a death sentence for most serious offenses, extremely grave. So the question is this a case of serious crime? In answering that question, I considered the following. What the evidence said. And the first thing that was revealed by the evidence is the manner in which the offense was committed. I want to remind ourselves of the judgment I delivered on 9th of February, where I indicated clearly that the evidence of the doctor who conducted the post-mortem report indicated that the person who perpetrated this offense cut the throat of the deceased through and through. In that judgment, I spoke to an understanding that the person was not an amateur. The person must have had some training. And remember, the evidence even revealed that after the offense was committed, the deceased was put in the bathtub and the shower tap was put over to run the blood off. When I read the report presented by the probation department, where the accused person himself says, I have been trained by the Dubai Police Academy and an Ogara group, I thought that corroborates the finding of this court that there was full scale for commission of the offense. I do recall saying in that judgment that the manner in which the offense was committed did not at any time intend to give the deceased one more minute to live. I do recall throughout the trial, no any other than the counsel representing the accused person in this trial throughout kept on referring to the incident and the scene of crime as a slaughterhouse. Secondly, we have had the benefit of looking at the photographs showing the body of the deceased and the injuries. I would certainly not display them there, certainly not, at least for the benefit of the family. And I did indicate in my judgment, no one would like to look at them again, not once, not twice. Now let's look at, and this is very critical, because it is not the court just making an observation, it was a brutal murder. Let's look at how the defense, or that is the submissions in mitigation by the accused person himself, describes the offense. I will now read to you how they describe the offense verbatimly. They say that it is a tragic, curious loss of life on extreme circumstances bordering on an act of absolute madness that is beyond understanding. So even the defense joins the victim's family and the prosecution and the court in arriving at the conclusion it was a gruesome murder. Horrific, frightening. Let's now look at another important aspect that the court has considered. The consequences of the offense. From where I sit as a court, each one of us is responsible for the natural and the probable consequences of our actions and or omission. So it's not just an issue of committing an offense, but the far-reaching consequences of that offense cannot be ignored. And so in this case, it is undisputed that the deceased was the managing director of the family's business in South Sudan. It is undisputed that the business collapsed after her demise. It is undisputed that that was the source of income for the family, and we can all appreciate the natural and probable consequences of that. I have already made reference to the fact that the other consequence of this offense is what has been described, and unless there is evidence to the contrary, I believed it because it's in the probation officer's report that the mother of the deceased suffered depression and stroke, and she has hardly healed. Has spoken to what the brother is said to be undergoing. This court, and I never lose out on anything, I try to get as much of in-depth of the material before me as I can, has been invited to take cognizance of the fact that the father of the deceased at one time said, I will let go. That did not form part of my record, because what formed part of the court's record is his sentiments as expressed in the Brevet report, and that is what I will safely go by. But I'll be concluding with one or two other findings that could probably remove us from that mind thought that the father said, do not, vengeance is not mine. I also want us to just, in concluding, other than looking at the manner in which the offense was committed and the consequence of the impact of the offense, I took a bit of time to look at the character of the accused person. I have already spoken to how the probation officer describes him: aggressive and social personality, and concludes he has double personality trained. But let's look at what else this court was able to gather while hearing this matter on the character of the accused person. It was the evidence of the guards at Royal Park Estate, where he was staying, that he would not allow himself to be searched. He would brandish a gun and say, I work at State House, and just drive off. It is the evidence of the brother of the deceased that even during the hearing of this case, at one time, he blocked his car when the case was going on. And of course, you have heard from the IO, even when he was out on board, he was still involved. I'm not condemning him because there's no child before me. But the court cannot avoid looking at this. Because at the end of the day, the question is this: is this a person you want to release back to the society? And these issues become extremely critical for consideration. Finally, this matter and the evidence adduced does not lead to a conclusion that this murder was accidental. That the perpetrator did not have an opportunity to think about the consequences of his action. It was intentional. It was not a defensive act. It was not out of provocation. It was planned, it was intended, and it was executed. And those who do not subscribe to Christian faith, bear with me. I do. And that's the only place I could make reference to. In the book of Job, chapter 1, verse 12 to 13, this is what is